Good afternoon, everyone. Thank you for being here. I'm going to start the presentation on the basics of Medicaid long-term care eligibility. I preface this with saying that it is a specific type of program under the Medicaid general set of programs. There are other types of programs, such as maybe the healthcare card or services at home that have very different rules than the long-term care eligibility rules. Today's focus is on the long-term care eligibility rules. There are 9 non-financial factors to Medicaid eligibility for long-term care. These are, of course, U.S. resident or citizen. You have to be a resident of Illinois. If you are over 65, there is medical eligibility that is presumptive. If you're under 65, there is an evaluation that the department takes you through to determine that you are eligible for long-term care. We're here, of course, today to focus on the financial requirements and asset protection. So the main financial requirements for long-term care benefits are the monthly income spend down, resources are spent down as well. And then there is a 60-month review of any transactions one has made in the last 5 years. This is commonly referred to as the 5-year look back. So our first focus, of course, is income. And my purpose of going through these rather basic rules is twofold. One, you sort of need an understanding of these in order to properly understand the mechanics of a Medicaid trust. And if at the end of this presentation, maybe that's something that does not quite fit into your strategies, at least you have the basic understanding of how these work. So turning over to income, there is a monthly requirement that an applicant for Medicaid long-term care pay over to the facility a certain amount. And that certain amount is determined very simply by looking at gross income. So gross income is not to be confused with net income. Net income, for instance, Social Security benefits, which is RSDI, retirement, survivors, disability insurance, that what you see in your bank account from the US Treasury is going to be net. We're starting at gross. So that's something to keep in mind, that this is very important. These are going to be added up and you get gross income. Now, every month, Medicaid does allow the payment of healthcare premiums. So these, of course, change year to year, month to month, depending on, for instance, your supplemental, when that changes and that sort of thing. In this example, all the total premiums of this particular client were $478.50. This is allowed to be deducted from the gross income. And once you make the calculation, this is what an applicant who is single has to pay every single month to the facility. The facility has a contract with the state where they're, guaranteed a certain amount for each Medicaid recipient. And so what they do is, if let's say, this is close to $2,500, say this were $2,500 and this contract with the state was $5,000, you would pay $2,500, the state pays the rest of the $2,500. So that's how that works. So there is a contribution that is expected. Even with all the planning that we may do, there is going to be some sort of income, whether it's Social Security or disability, or even a pension or annuity or other types of income. And we won't get too much into that, but there are certainly more types of income than what I've outlined here. If there is a spouse, the rules change a little bit. So the spouse is allowed to keep, without question, $2,739 per month. This is not exactly a vast amount. So it is something to consider. If there are assets or income for the community spouse that's a little bit higher than this, it doesn't mean that the community spouse is going to have to pay dollar for dollar. in terms of contributions for the applicant spouse's monthly pay. But there will be some sort of contribution that's based on a chart that Medicaid puts out. Don't be too afraid of this. Honestly, I had a client who they were, mid to upper 50s, and he went into a facility. She was still working. She was making $80,000 a month, and a year, if only, $80,000 a year, and her monthly contribution ended up being $810 a month. That's still significant, but long-term care costs in that case were about $10,000 a month, so it wasn't quite as bad as having to pay that amount. Going back to this and how this works, if, for instance, the community spouse makes only $739, the spouse in the facility is able to transfer $2,000 to the community spouse to make up the difference. Turning over to how this might apply to a Medicaid trust, the assets that you would transfer to a Medicaid trust, in theory, would be invested in some sort of, whether it's stocks, bonds, or annuities. It's going to give potentially some sort of income if you make some good investments, if it's structured correctly, and if you want it to be this way. Income could be trapped inside the Medicaid trust, so that income would not be counted in this calculation, and that income is then preserved, stays within the trust, and continues to be invested and increase in value. Now, turning to resources, what most of us call assets, and I do use those terms interchangeably here. There are resources and then there's assets. They're the same thing. Medicaid, for whatever reason, has called them resources. They changed that from assets a few years back, not sure why. So you are allowed to keep certain resources as a single person, and also if you're married, they are the same if you're the applicant. The only difference is the homestead. If you have a homestead and you have a spouse, there's some different planning than what's outlined here that can be done. Now, the applicant spouse is allowed to keep $2,000 if they are single and the homestead is still in their name and has to be listed for sale with an agent. So it can't be a private sale. And at application, it is an exempt asset. Later on, if it's sold, it's subject to spend down, which we'll go over in a moment. Personal effects, they don't really look at that. A lot of people worry about, wedding rings or engagement rings that can be, of great value. And that's something that, don't worry about those things. They don't come after this. Of course, if you have a Picasso sitting in your living room, that's slightly a different story. Term life insurance, an auto used for transportation for medical purposes for the applicant spouse, burial space and funeral. This is a short list. There are some other things that can be done, but this is the most common types of resources that an applicant can keep. Now, if you have a spouse, you have your community spouse, and that spouse is able to keep $109,560 in resources and the homestead, so long as the equity value is no more than $603,000 in 2020. This is actually tagged to inflation, so this changes year to year, so every year we have to look this up. Personal effects, carve any value with no limit, so there's no limitation that it has to be for medical or employment use or anything like that, just carve any value. Term, life insurance, burial space, and funeral pretty much mirrors what the applicant spouse can keep, but for these two, there are other resources that can be preserved, but those require some planning, such as a Medicaid trust, and other types of techniques that we use that I don't go into here because it's not as common. Spend down of resources. So here's where kind of the rubber hits the road. Resources over these exemptions have to be paid down to the facility until you get down to those limits. This includes the community spouse. So if the community spouse has over the limits and has 109,560 and say another 100,000, that is expected to be paid down until you get to the exempt assets as well as the 109,560. So that often comes as a big surprise, but that's something that I really want to make sure that people are cognizant of. Now, what is available is anything that can be distributed to, liquidated, or controlled by the applicant or the community spouse. And so what we do is, perhaps use a Medicaid trust. There's other techniques, but today we're focusing on this, where we're moving those non-exempt resources into a Medicaid trust. The way it's written is what makes it an exempt resource. So anything that's transferred into a Medicaid trust is going to be administered according to its terms. And so the terms are going to limit the way that that money can be used, and that then turns it into an exempt asset. However, there's the timing issue. We have the 5-year look back, and that can cause penalties. The 5-year look back is where Medicaid analyzes 5 years worth of statements, transactions, sales, anything you've done for the last 5 years prior to the date of application. And they're going to be analyzing and looking to make sure that all transactions were allowed. And allowed transactions are those where you have fair market value, okay? You receive something in return for whatever goods or services that you are purchasing. And they look at it for the community spouse too. So if you have an applicant, both that is married, then the applicant and the spouse both have to have received fair market value for any transactions in the last 5 years. The presumption is if you cannot verify that you've gotten something in return, or you literally gave your assets away, that you did it for purposes of qualifying for Medicaid long-term care benefits. So you know how there's a presumption at law that one is innocent until proven guilty in the criminal law forum? Here you have to prove yourself innocent of having transferred assets. It's a little backwards, and it's a very cumbersome process, actually. So non-allowed transfers are anything literal gifts or unverified transfers, meaning you can't prove that you got fair market value. So the consequence is Medicaid imposes a penalty for these transactions. And what they do is that penalty is as of the date of application, and it's measured in months. So you can be approved for an application, say if you were to apply tomorrow, April 1st, and have a 3.5 month penalty period. So they won't pay April, May, June, and half of July. Okay. If you were over-resourced, this is almost an aside, but if you had too many resources, they first make you spend down to the required limits and then apply the penalty. So you can have a double whammy. You can have too many resources at the time of application, and also a penalty that is imposed directly after you spend down. So the calculation of the penalty is the total amount transferred over the course of 5 years. This can get big or this can be absolutely zero. I've seen both, divided by the cost of the facility. So these are unverified cash transactions, $25,000, a gift to the grandchild for college. It was fair market value, but it wasn't fair market value to the applicant, therefore it's a gift. If the cost of the facility's daily rate is $240, which is actually on the lower side, we are seeing more like $300 nowadays. But going with these numbers, the monthly rate is this of $7,200. You have 3.5 months or so that they won't pay for care. So with a Medicaid trust, The act of transferring money into the Medicaid trust produces a penalty. The trust itself, and we'll go over this, is a type of trust that the provisions of it make it exempt, but the act of putting money into it is going to be penalized. So the strategy is to wait 5 years prior to applying, and we'll reiterate that in a moment. Now, I want to make sure that we make a distinction. This is not a regular type of trust, hence the title. This is a very special type of trust. It's not like you see with respect to your regular revocable trust, where you are the trustee, you're the beneficiary, you fund everything into the trust. This is a very special type of trust, and it works in conjunction with those types of revocable trusts. But the Medicaid trust, in order to work as an exempt asset, has to have no spend down of income, or has to have provisions that, if they're structured correctly and timed correctly, you don't have an income spend down, you don't have an asset spend down, and there's a potential transfer of wealth to the next generation, okay? And if you wanted to contrast a revocable trust, you can view our last month's presentation by Alex Jaraka of our firm. You can find it on our website under her profile, where she goes into how those types of trusts work. So the timing and structure. First and foremost, you're going to have a 5-year wait, no distributions to either spouse, no control to either spouse, no amendments, no revocation. Due to all of this, as that's a lot of not having control, there is a little bit of a protection through the trust protector. And then finally, we go through asset considerations. Every person or couple's financial assets are a different mix, and they're going to have different needs depending on what you have and different consequences. So the 5-year wait, I reiterate, whatever you fund into this trust to protect it, you have to wait 5 years before you can apply. So 5 years is 60 months. You apply on the 61st month, okay? No distributions. And by no distributions, you are making it such that neither income nor assets can come out. Therefore, you have no income spend down, no asset spend down. There can be distributions to others during life. There cannot be any distributions either to the community spouse or to the applicant. Other beneficiaries often are children, and those children could potentially receive a distribution during life. Now, that beneficiary child could decide to help mom or dad out on whatever need they may have, but they're not legally required to, and cannot also have informal requirements to do so. These are often called safety valves, and they're meant in case you get it maybe to 55 months instead of 61 months, and you sort of need a little bit of a gap, and you're willing to take it out from what had been earmarked as, part of the trust assets to be distributed potentially to the next generation. We have these just in case. It should not be a frequent use, and it should be mostly an emergency type of thing. Distributions at the death of the applicant or of the second to die of the applicant or the community spouse can go to beneficiaries such as children or brothers and sisters or nieces and nephews. This is where the asset transfer to the next generation or within the family can occur. Now, the next topic is no control. So the trustee cannot be either of the spouses, or if it's just a single person, cannot be the applicant. This is where a lot of people feel a bunch of discomfort. You have spent your life pulling together your savings, working, taking care of family, and all of a sudden, in order to get benefits, you have to turn over the reins to someone else. You're not able to get distributions. This lack of control is not comfortable to folks, but it may be worth it if there is this strong desire to save these assets and potentially transfer them to the next generation. The trust cannot be amendable or revocable. This really is very much related to the control issue. If you can amend it or revoke it, then you have control over the assets. So that's something that is very key to making eligibility through a Medicaid trust. Now, there is the subject of the trust protector. They can be given authority to amend the trust, but for very, very limited purposes. So if there are updates to the tax law, they can maybe update that. If there's some administrative provisions that need to be included, they can do that. If there are maybe some drafting errors that are not, let's change the distribution completely, then those can be done. If there is a trustee that is rogue, doing bad things, stealing, or not, being responsive, they can remove that person as well. Obviously, you would try to pick a trustee that is, trustworthy, but the trust protector would be there to remove them. This can be a trusted family member, some sort of financial institution, an attorney, that sort of thing. It should be someone who's a little bit removed from having a stake in the ultimate distributions. This person can also make these special distributions that I had alluded to earlier in the form of a distribution of income and principal, or the assets, to certain beneficiaries. Now, funding the trust. This is where it gets a little bit more customized for clients because it depends on what it is that they have. First and foremost, of course, there's a 5-year wait. You're not expected to put every single dime into one of these Medicaid trusts. You're going to reserve out what you need to meet your living expenses. So we're going to dive deeply, at least that's what we do. We dive deeply into budgets, factor in a little inflation, factor in maybe some expected increases of income, which may be modest, as well as if there are some assets that you're going to be living off of that will need to be liquidated. If those are going to cause any taxation, we're going to need to factor that in. If there is a community spouse, there are several other techniques that can be used to preserve assets, such as refusal, or in very limited circumstances, court orders or administrative orders to increase the resource or the income limits. So this is something that we can use for a community spouse, but there are other things that can be utilized, or other techniques that can be utilized. But from time to time, this does occur. I've had a couple clients who did this. If there is planning for a community, where we did benefits planning for both the community spouse and the applicant spouse, we reserved out just what they would both need for 5 years, and then just kind of let them live off of their income and whatever they had reserved out. If there is no need, then we're going to reserve out the exempt assets that the community spouse could keep, as well as putting into the Medicaid trust what we're trying to preserve. So challenging assets to do this technique with are retirement assets, so 401ks, IRAs, that sort of thing. If there are annuities that still have surrender fees, so if you're in your surrender period, this is going to be challenging. Or if there's assets that are going to produce a lot of taxes upon liquidation in order to fund this trust. So for instance, if you have stocks through your company and you've got them at a really low cost basis, meaning you paid very little for them. If you liquidate them, you're going to have some significant taxes. So we're not saying that this cannot be done with these, but these are serious considerations when doing it, because you may, lose out on quite a bit of money here. That notwithstanding, I had a client once with an IRA of $1 million and proceeded with a Medicaid trust, and they invested it well and were able to wait out 7 years. So it can happen. Income considerations. So income considerations, sometimes you are transferring assets into a trust that produce income. I once had a client who had a rental property. It was multiple units. This was what they were living off of. It also had a commercial rental unit at the first floor. And so it was a significant source of income. So they needed the income in order to survive the 5 years. And so what we did is we allowed the Medicaid trust to distribute income. When you do that, of course, now that could be income that is expected to be paid down to a facility when you apply in 5 years. You can add some provisions to prevent that by setting off a trigger if the real estate is sold, income stops coming out, or if the person moves into a facility, perhaps we can trigger it so that it stops at that point. But the income portion of it is a little bit more malleable. You can, sort of see what you have and, customize it to fit a need. Now, you don't have to have a ton of money in order to do this. There are times that folks have simply just preserved the home. I had a gentleman who was a cyclist, had a very bad accident, and became paraplegic. He's at home, and he has sufficient in pension and income and some assets to stay at home for a while. He's relatively young as well. And so he just put his condo into the Medicaid trust and expects to wait out, 5 to 10 years before he needs to go into a facility. So this is something that is still useful, even if there are not a ton of assets that you can transfer to a Medicaid trust. You can at least save your homestead, which tends to be a big emotional factor for a lot of clients. So in conclusion, before we head off to our question and answer portion, Medicaid trusts are a significant tool that we can use. We can use them for various situations, whether it's someone with, a significant amount of money or modest amounts, or you're just trying to save home. They are very dependent on the situation. So if you have a diagnosis of something or a condition that will take some time to really take hold, it seems more appropriate. If it's someone who maybe needs to go into a facility soon, then this is probably not the way you want to go. There are other techniques that we have for what I call immediate planning. And as you can see, there are quite a bit of restrictions that are imposed for this to work as an exempt asset. You have to wait the 5 years. Once you wait the 5 years, any transfers to the trust cannot be penalized. And then terms of the trust have to be written in such a way that it is counted as exempt. Okay. So at this point, we're just